Welcome to Estate Planning Beyond the Binder.
Welcome back to Estate Planning Beyond the Binder with Brian Chu. Brian is the managing partner at OC Wills and Trusts and has over 25 years of experience guiding families across Orange County through estate planning, asset protection, and legacy planning. I'm Kevin Rosenquist, and today we're talking about how divorce impacts your estate plan. From wills and trusts to beneficiary designations and guardianship choices, divorce changes everything, and failing to update your plan can definitely leave your family exposed. Brian, good to see you.
Hi, Kevin. Thanks for having me on again.
Yeah, so just divorce, obviously, it rocks families and plans and all that. But you know, when you think about an estate plan, there's so many other things happening during a divorce. That's probably something that people will often forget to worry about or to take care of. Can you talk about why it's so essential to revisit that estate plan after a divorce or even during?
Yeah, obviously, when we unfortunately have clients, they did a joint trust with us, when things were better, and obviously that's if something happened to one or both of them, there's a plan, who's in charge, where everything goes. Obviously, once you get a divorce, the biggest thing and the part that people really want to change, it may not even be where the money goes. Especially if they have joint children, they're still probably planning having the money go to their kids. The problem is, obviously, usually there's an issue with the parents or the couple in this case where they don't trust each other anymore. Mm-hmm. And these documents are all built on the premise that, who do you love, who do you trust, and how much you trust them? Well, those last two questions now, which is the first part of it, which is assuming you trust, and when you're married, you trust each other, a lot of times is out the window, unfortunately. And so that's right. The number one reason why we're updating people's documents, because the people they put in place in these documents are not the people they trust anymore. Okay. Even if they trust them with the kids, they might not trust them. I always tell them it's one thing. Yeah. If they become in charge of the money, something happens to you, they become in charge of the money on behalf of your kids. Okay. That's one thing. But do you trust that person to be in charge of you? Mm-hmm. Okay, it's currently on the document. They're in charge of you if you make medical decisions. If you became incapacitated, they have access to all your money and can make decisions on your behalf. At that point, they can sign on your behalf, and you just may no longer be comfortable with that.
Yeah, that's a good point too, because a lot of people might think about the asset part of an estate plan, but you're right about that power of attorney and the medical. The what I'm blanking on the document, the medical power of attorney, right?
Healthcare directive, yes.
Yeah. So that you probably don't think about that as much.
Yeah, I mean, again, it's obviously a lot of times it's who do you trust that person anymore?
Yeah. Do I want my ex-wife deciding whether to pull the plug or not?
Exactly.
Pull the plug. He just has a broken finger. Pull the plug. So what kind of problems have you seen over the years when someone forgets to remove their ex-spouse from a will, a trust, or a beneficiary designation?
I mean, I'll be honest, fortunately, usually that's not the issue. Yes, in theory that, that spouse surreptitiously could do things, so it's from a practical standpoint, it's not as much of an issue as far as that somebody's going to abuse the documents that they right. may still be on. Really the issues is, once you get divorced, your assets move, and presumably they're moving outside of this trust that you created, this joint trust. So now the assets are back with the individual, the individual, spouse, and now they don't have an estate plan. So that's usually the biggest issue, is that they're not creating a new estate plan for themselves after they did it, because obviously, unfortunately, the divorce is causing other issues, and so the estate planning part doesn't seem to be on the forefront. But now, effectively, even if they have documents, some of those documents are no longer effective because, like I said, the trust, this joint trust, you've presumably moved the assets out of the joint trust back into your own name at the end of the divorce, and so that obviously creates a problem. The other issue is that some people think, well, we get along well enough, and we want everything to go to our kids, and that's fine. And the trust, obviously, if something happens to both parents, even in that case, sometimes they trust each other enough that the survivor gets everything. Which again, that's an issue. Do you want the surviving spouse to get everything? And then B, even if it does go to the kids, the issue moving forward is, sometimes we have parents, they want to keep everything in this joint trust. The problem is when you are married, you're from a tax perspective, you're seen as one. So you putting assets into a joint trust, doesn't matter whose assets it is, it's considered both of yours, and that's fine. But if you're in a joint trust and you're not married, now you're seen as two different people, and putting assets into a trust at that point can be problematic from a tax standpoint. So that's why, once you're divorced, you need to do something else.
What about beneficiary designations on things like retirement accounts, life insurance, that kind of stuff? Maybe life insurance might be different because you do that separately, I think. But how do you, what happens in California after a divorce? Does that stuff in retirement accounts automatically change? Or do you have to go in and actually change that?
That's going to be a result of whatever the settlement is. So it depends. So if the spouse is deemed to be still going to be the beneficiary on the 401k, because it's usually they're
marital income,
find some sort of settlement where, depending on who has 401ks, they'll just go their own way, or the one spouse needs to be at least a 50% beneficiary on the 401k up to that point. So it is just a matter of what do they settle on, and as part of that settlement, whether they have to keep the other spouse on as a beneficiary. Sometimes in those divorce proceedings, in order to make sure that especially if one spouse is dependent on the other spouse for child and or spousal support, they'll make sure that they'll require that spouse, the one that's earning the income, to get a life insurance policy and make the other spouse, the beneficiary.
Okay.
But that'll be all part of the settlement in the divorce. But obviously, if you do have control of that account, and again, especially you have minor children still, you can update those accounts to have your kids as beneficiaries now instead of the spouse. But because they're minors, if you do name them instead of having something like a trust, that money would go to probate because they're under 18, and the courts have to decide who's in charge of the money if something happens to you. So that's why that's why you want to create, anytime you have minor children, you want to have something like a trust so that you can name the trust as the beneficiary on the account that will not be subject to probate versus naming your kids.
Do both parents have to go in and do this together? Do they do it separately when they want to change an estate plan after a divorce?
They typically both. Sometimes they will come. Good. Fortunately, I've dealt with some cases where they come in cooperatively, and they're going to do their own separate planning, but they're effectively going to do it at the same time because they're good news is they're amicable enough. They're in agreement in general what should happen. Mm-hmm. Again, at that point, they're going to go their own way in terms of choosing, or maybe sometimes the same way as far as who's going to be in charge after them. But so sometimes they'll do it, kind of cooperatively. But again, even if they do it cooperatively, once it's individual plans, you can do anything you want. Right. So you can come back in the next day and change it if you want. But other circumstances, obviously, we have just a single one. One will come in and update their planning, and the other one, will potentially come in and update their planning.
What happens if one goes in and update their plan and the other one doesn't?
Well, so at that point, they're creating their own plans.
Okay.
So they don't need it. The only thing we need them to be cooperative about is if the assets are in the trust. In other words, like the house, if it's deeded, the title is deeded into the name of the trust. We typically, in order for them to, and again, this is assuming somebody's going to own it, or obviously they sell it, it's different. But if one of them's going to own it, then the other one needs to deed the property to the other person. And so ideally they'll deed it, we'll create a trust for one of the spouses, and then the two of them will deed the property from their joint trust into the single trust. Obviously that's when the most cooperative. But again, at the end of the day, if it's part of the settlement, the spouse who's giving up the interest in the property is required to deed it to that spouse. Mm-hmm. Now, if they just deed it to the spouse, then we need to do something to put it into that spouse's new trust. So again, you can do and even if you're married, you can do a single, your own estate planning. But it's where the assets are, who's on title of those assets doesn't require a cooperative effort at that point. But creating the documents itself, it doesn't require it to be cooperative at all.
Okay, that makes sense. What about prenuptial agreements, postnuptial agreements? Do they play into the estate plan like this at all, or is that just more about the divorce settlement?
Anytime you have an agreement, whether it be a prenuptial, postnuptial, or any kind of contract, your estate is subject to those agreements. Mm-hmm. So obviously, in the case of divorce, obviously the prenuptial and antenuptial agreements, there are, those will be executed, as part of the settlement. If something happens after you pass, if I'm married and I pass, any postnuptial or prenuptial or antenuptial agreement and I especially don't, if I want that money to go to somebody other than my spouse, if I pass first, it is subject to those agreements. So I can only pass to somebody else, like my kids, whatever I'm entitled to give away. In fact, that's what we tell clients. We have clients come in all the time that are married but want to do their own planning from one reason or another. We say that's fine, you can do it, but it is subject to the claims of your spouse. And because your spouse is not party to this trust, again, at best you're saying in your estate plan, whatever I'm entitled to, this is where I want it to go. And what I'm entitled to give away will be determined at my passing. And I always tell people, death is like divorce. When somebody passes and you're married, if to the extent you give everything to your spouse, okay, no problem, it's not an issue. But if you don't give everything to your spouse, then the question is, are you entitled to give it away? In California, you're entitled to give away 50% of the community property and 100% of the separate. Obviously, if you had an antenuptial or postnuptial, prenuptial agreement, that might help determine what was community versus separate property. Community property is what you earn over the course of your lifetime, or anything you buy with money you earn over the course of your lifetime. Over the course of your marriage is split 50-50. Separate property is money you had prior to marriage, and or money you might inherit, as an example, during the course of marriage.
I've talked to divorce attorneys before, family law attorneys, and that is a very contentious thing, community property versus separate property, because a lot of people don't realize just because you bought it, like, and maybe you make more money, doesn't mean that it's not half your ex-spouse's, because that's what community property is.
Yeah, I mean, there's that who earned it, and then it doesn't really matter, and then whose name it's in. A lot of people think, oh, I have this money separately in my name, that's my money, and that's not necessarily the case.
Right? Or cars. The car's in my name. It's like, well,
or the house. It could be anything.
Yeah.
It's all about, where did the money come from to buy that house, and or if it's if you have, let's see, it might even be a separate. You inherited the property from your parents, and there's a mortgage on it. Where's the money coming to pay for the property taxes, insurance, the mortgage payments? Is that money coming from your job, or is that money coming from from a separate source? That your parents have enough money that you could use that money that you inherit from them to pay those things. And those, again, that's a family law issue, but it does come into play with estate planning. If I say I want all my money, if I pass away, I want all my assets to go to my kids. If I pass first, which we see quite often in estate plans, the question is, what was my money? And again, that I always tell them, the kids and the surviving spouse are going to negotiate that, just like in a divorce. What was community? What was separate? It was 50% of the community and 100% of the separate. I'm entitled to have it go where I want it to go. But that'll be a negotiation between if that was if I were doing it that way, between my kids and my spouse, as far as what's the outcome there.
You've seen a lot of families go through this over the course of your career. What generally do you see goes wrong when someone doesn't update their plan accordingly after a divorce?
I'll be honest, I haven't seen it's in a lot of times more, not to say hypothetical, but if this did happen, it would be a disaster. The good news, if we actually see it, that means they're coming in and fixing it. So we haven't seen a ton of the aftermath. In this case, somebody dies, and somebody disaster. I guess I just recently I had a client who's, unfortunately, she has stage 4 cancer. Her husband, and they're not divorced in this case. He's living in another country, and they're wanting to get things done. And now it's really even though they're not officially divorced, they are effectively divorced, and so she can't just ask him to do things. And so a lot of people just leave this to when it's almost too late to get things done. And again, as long as everybody's reasonable, even if you make mistakes, it can probably be undone. But again, there are, if people really want to enforce their rights, things might not go the way you want them if you don't update your planning. And that's really, that's what we've seen. We told people, if that person really wanted to do something, and it would be harmful, legally they can do it. Fortunately, for the most part, these people, they haven't necessarily enforced their rights, and things have gone the way it should go, but you never know. And that's what we're trying to govern against. We have to assume the worst is going to happen. Fortunately, most of the time it doesn't happen, but if it did, not having a right plan in place, well, that's what can prevent the worst thing from happening.
What do you want to adjust, or do you want to look at this during the divorce? Do you need to wait till after the divorce, or should these go kind of concurrently?
I always tell clients, if even if you think you're headed down that path, that's when you want. Usually the biggest issue is, do you trust that person anymore?
Right.
Okay. Sometimes they can't live with them. Okay, and maybe they trust them, especially if they have joint kids. They can trust each other. Okay, it's not as urgent, but certainly, we have the situation where you don't trust that person. That person has issues. Um, whether it be with you or other people and stuff like that. So you got to get them off your documents. You got to get them from being in a position of making decisions for you if you became incapacitated. So that's the urgency usually is, if you're incapacitated, especially who's in charge. The thing, the only issue, and while I understand, usually in talking to these clients, we know the division of assets is not going to be settled for a while, until the divorce is final. And that's fine. But there are assets that are potentially in your name that you can put in the trust. And as long as that's comfortably, you feel comfortable, that'll be well within your share of the assets, and that's not a problem. But, so we'll deal with the assets as you gain control of them throughout the divorce proceeding. But at the very least, we want to make sure, again, it's all about who's in charge when you can't be. And if you don't trust that person more, you need them off your documents, and you need them off as soon as possible.
Yeah. Yeah. And obviously in divorce, there can be a lot of trust problems there. So makes a lot of sense. All right. Well, thanks for tuning into today's episode of Estate Planning Beyond the Binder. Divorce brings huge changes, and your estate plan needs to keep up. So updating those documents really helps prevent confusion, conflict, and unintended outcomes later. So to learn more and schedule a consultation, visit ocwillsandtrusts.com. Don't forget to like, subscribe, and review today. We love having you be part of our community here. Brian, always great chatting with you. Thanks so much for being here.
Thank you, Kevin. Have a great week.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.